Thank you. Gosh, you put me on the spot with how do I fit baseball into this? Thank you very much for the invitation today. It's a pleasure to be here. My first trip to the campus, it's gorgeous, really a pleasant place to hang out. It's also pleasant to be here for reasons that are related to the talk. Some of you may not know, but although the BC Civil Liberties Association took the Carter case, the main litigant in this case was a woman who suffered from ALS called Gloria Taylor, who lived most of her life, in fact, in West Bank and around Kelowna. Gloria is no longer with us, but she worked closely with the Civil Liberties Association, and me coming back here today means quite a bit to me, in the sense in which the Civil Liberties Association, Taylor put together, and other individuals put together this case. And I want to talk about where to go from here. At least the conclusion of my talk will be, what should happen in the wake of Carter. In a way, the legal and ethical issues are not done with. Also, being the first speaker today, I thought I would start by trying to put this case in a bit of context. And so one of the things about the physician-assisted dying debate, the euthanasia debate, is I think that there's a tremendous lack of sort of public knowledge about the history of the debate in Canada, and also about the ethical issues and the related evidence around that. So I want to set the context, put it in that context, and then talk a little bit about where we might go today. I suspect that some of the things I'm going to say will appear a little provocative. I don't think they should be provocative. They appear provocative to the extent that people don't understand the issues and the evidence. And I guess my bottom line is we really do, particularly in these types of cases, as we do in medicine, but we should take what you call an evidence-based approach to policy here. So here's a picture of our famous Art Deco building of the Supreme Court in Ottawa. The outline of my talk today is, as I say, I want to put it in a bit of context. I'll talk about the history leading to Carter. I want to talk about the elements of the Carter decision, because I don't think that's well understood, at least in talking to my students and colleagues. I think there's misunderstandings about the limits of Carter. And so on. And I want to talk about the legal and ethical implications. The Supreme Court decision itself is accessible. I encourage you to read it, and I hope this PowerPoint I hope can be made available to people today. There are links there to the Carter decision. People ought to read that decision carefully. And I want to talk, as I said, I want to talk a little bit about after Carter as well, and where we might go from here. So it's hard to stress the extent to which this is a landmark decision and a unique decision in many ways. In fact, if you go for the history of the Supreme Court of Canada's decision since 1982, when the Charter was put into effect in Canada, it would be hard to find a decision that potentially impacted more Canadian citizens than Carter. So the basic result was that the Supreme Court ruled that there is a limited right to physician-assisted dying in Canada. They recognized a limited right to physician-assisted dying. And by physician-assisted dying, I mean it's legally permissible in some circumstances, and we'll define those more carefully in a moment, for physicians to provide patients under some circumstances with the means to end their own lives, so what's often called physician-assisted suicide, and also for physicians to administer a lethal substance to patients. In the past, if you've taken philosophy courses in this, we often talk about euthanasia and physician-assisted suicide. Physician-assisted dying combines those two ideas. It's the first such ruling by a national Supreme Court in the world, a clear ruling defending physician-assisted dying. That's remarkable in itself, but what is I think equally remarkable is that it was a 9-0 decision. It was a unanimous decision by the court. No one anticipated that. I think I had a little bit of an inkling when I watched the court cross-examine the government's lawyers. It seemed to me, I mean, they're fairly poker-faced, but the questions they seemed to me to be asking of the government showed, I think, a degree of skepticism about some of the evidence that the government was leading. So I mean, I thought we were going to win, but I would not have bet that it would be a 9-0 decision. A little known fact about that 9-0 decision was they didn't attribute authorship to whoever the author or authors were in the legal decision. So usually if you look at a court decision at a superior court where you have usually you have a number of judges hearing a case, authorship is attributed to noted to the person or the judges who write the decision, and then the other justices are noted as concurring. In this case, it was simply reported as the court's decision, and I think the reason for that, the court does this, the Supreme Court of Canada does this in cases where it wants to show that it is particularly united, and I think in particular in this case what they wanted to show was whoever wrote the decision, whichever justices wrote the decision, it may have just been one justice, what they wanted to show was that their unanimity cut across so-called conservative and liberal voices on the court, that this shouldn't be attributed to a particular activist vein in the court or conservative vein. So it's a very important point to note about this decision. The other thing is that they suspended the declaration for a year to allow the federal governments and provincial governments to adopt laws to regulate physician-assisted dying. And I'll have quite a bit to say about that later on in the talk. So here's the history. Come on in. So I'll give you a bit of background here. The two main pieces of legal evidence in this case are the Criminal Code, the Canadian Criminal Code, and the Charter of Rights. I think it's fair to say that we probably would not have had, almost certainly would not have had this decision if we were living in the pre-charter era. So the relevant provisions of the Criminal Code that were under discussion in this particular challenge, Section 14 and Section 241B. Section 14 basically says it's not a defense to murder that someone consented to be killed, right? So that's Section 14. And then Section 241 says that it's an offense if you aid or abet an individual in committing suicide. The implication of that, of course, we'll see in the wake of Rodriguez especially, the implication of that is that providing the means of death, right? That is, providing, say, pills that someone might take to commit suicide, or administering a lethal substance, would be criminal acts either of assisting, actually assisting suicide and or murder. So that was the assumption of what the law required up until Carter, and it was why Carter and the Civil Liberties Association and other individuals wanted to challenge those provisions. The relevant parts of the Charter of Rights are Section 1, Section 7, Section 15. Other parts of the Charter have been used in other challenges, but these were the key elements. And it turned out that the key section that was used, that was discussed in this context, was Section 7. Everyone has the right to life, liberty, and security of the person. If you know your constitutional law, you know that there's a sort of two-stage step of demonstrating that the government in some way has violated charter rights. You have to show that there was a violation under a section like Section 7, and then there's a test to determine whether or not that violation could be justified, demonstrably justified, if you look at 1 there, demonstrably justified in a free and democratic society. And essentially what happened in this case was the Supreme Court of Canada determined that the blanket, the absolute prohibition on physician-assisted dying violated Section 7 and was not saved. The government's action was not saved by Section 1. The Civil Liberties Association and Taylor also made a Section 15 argument. The court eventually said that we don't have to address this because we've already determined that there's a problem with respect to Section 7. Okay. Andrew's already mentioned the Rodriguez case, another British Columbia case. I'll maybe pull, or I'll maybe toot the horn of the BC Civil Liberties Association a little bit. We weren't very much involved in this case, but I think one of the reasons that a lot of these decisions, these interesting charter decisions, come up through British Columbia is because of the role of organizations, in particular the BC Civil Liberties Association has played in promoting charter challenges. So just a bit of background. This is a picture of Sue Rodriguez there. She suffered from ALS. She was, at the time that she was making the application to the court, she was confined to a wheelchair. She petitioned to have those sections of the criminal code ruled invalid for the purposes of requesting a physician to assist her end her life. The Supreme Court of Canada, in a split ruling, right, 5-4, so a very different dynamic over 20 years ago, said that the reason that exception was there, that blanket exception was there, was to protect vulnerable individuals, and that though her Section 7 rights had been violated, it wasn't arbitrary or unfair because we needed that blanket exception in place, or that blanket prohibition in place, that absolute prohibition on personal liberty is a thing that is demonstrably justified in a free and democratic society in order to protect vulnerable individuals. Okay, so that's the Rodriguez case. The conclusion of that case, interestingly, and we can talk a little bit about this too if you like, is that a year after the Supreme Court came down with its decision, she was able to obtain the services of a doctor who anonymously administered a lethal substance to her. It was a publicized, some of you won't know, but it was she publicly announced that she was going to do this. There was a member of Parliament there, Sven Robinson, accompanied the doctor, was there when Rodriguez died. No one was ever prosecuted for that. I remember at the time talking to the Attorney General about that, and it's an interesting story as to why no one was ever prosecuted. The short answer is there wasn't really much of an investigation that was undertaken. So roll forward 20 years, nearly 20 years nearly 20 years to the Carter case, which starts in 2011, really. You have several parties challenging the prohibition of physician-assisted dying. Gloria Taylor, the family of Kay Carter, who had gone to Switzerland and received made use of the services there of their physician-assisted dying laws. We're thinking of putting together a legal case at the same time that the BC Civil Liberties Association was, and fortunately there was a geographic proximity, and they joined together to make a challenge. So you have a number of individuals that included some doctors, but the main litigant in this case, from my perspective, is Gloria Taylor. She was the affected party. She was the person who had particularly wanted to access the services of a doctor. So, in 2011, a suit is filed in the Supreme Court of British Columbia challenging those provisions of the criminal code. There is Gloria Taylor. She was successful at the Supreme Court of British Columbia level. So, the Justice Lynn Smith, former dean of the law school at UBC, essentially said that the prohibition was too broad and violated the provisions of the criminal code. We'll talk about the ways in which she did that in a moment. As the Supreme Court of Canada did, the Supreme Court of BC suspended that decision for a year to allow the government to change the law, but they made an interesting exception. They said that, however, Gloria Taylor does have the right to make use of physician-assisted dying if she so chooses. And in fact, she died of natural causes about a year later. And in fact, this is a very common thing. If you look at the evidence from Oregon and other jurisdictions, people often request physician-assisted dying, and in particular physician-assisted suicide. They will get the suicide kit from the doctor. Roughly about 50% of those are ever used. People die of natural causes or they choose not to use them. In her case, she died of natural causes, a bit unexpectedly. So what I'll do now is talk about the elements of the Carter decision as it was determined by the Supreme Court of Canada. The first issue was that the Court of Appeal overturned, the BC Court of Appeal, which is the highest court in British Columbia, overturned the BC Supreme Court decision, not on substantive moral grounds so much as by saying that the lower court was bound by the precedent set in the Rodriguez case, right? Despite the fact that the Supreme Court Justice, I think, and as the Supreme Court of Canada eventually agreed, carefully distinguished the law and the facts in the Carter case from the Rodriguez case. The Court of Appeal in British Columbia didn't accept that and said that the lower court was bound by the ruling in the Rodriguez case. So Supreme Court of Canada says, no, we're not bound by the ruling in the Rodriguez case. Why? Well, the law had changed, as Andrew mentioned. In particular, principles of charter interpretation had developed. You have to remember that in 1993, when the Rodriguez decision was brought out, the Charter of Rights had been in effect for just over a decade. In legal terms, probably less than a decade. So that principles of how to interpret and apply the Charter are evolving quickly during this period, and in particular the Supreme Court of Canada said they weren't bound by Rodriguez because since then the court has come to a different understanding of what overbreadth, a law that overreaches its legitimate boundaries means, and also this notion of gross disproportionality, using a legal sledgehammer to kill a legal fly. And then they said something that was very interesting. This is an earlier case, another landmark case in Canadian history from the Bedford case, which is the case that struck down the prostitution laws in the criminal code. They said that we can also look at a case where the circumstances and evidence fundamentally shift the parameters of the debate. And the key element there was that in 1993, the court, at least, didn't recognize that there was enough evidence, sociological evidence from other jurisdictions, to be able to say whether physician-assisted dying was something that could be done safely without exposing certain classes of individuals to abuse and misuse. The Supreme Court of Canada says, in the meantime, the evidence has become clear, and that shifts the parameters of the debate and entitles us to relook at the case, and indeed entitled the Supreme Court Justice of BC, Lynn Smith, to re-examine the case. They find, agreeing essentially with the language of Lynn Smith, Justice Lynn Smith, that Section 241 and Section 14 infringe Section 7 of the Charter of Rights. In particular, infringes the right to life, infringes the right to liberty, and infringes the right to security of the person. On each aspect, in other words, of Section 7, they found that the law violated the Charter of Rights. In the links you have here, you can go and see the factum produced by the BC Civil Liberties Association for each level of court. It is probably the most comprehensive collection of legal, social, and moral evidence ever mounted in a legal challenge. But in particular, the Supreme Court of Canada relies on the sociological evidence from other jurisdictions about the experience of physician-assisted dying, physician-assisted suicide, and other jurisdictions, and they find no convincing evidence of abuse or misuse. They acknowledge that the other systems aren't perfect, but they do the job in a way that meets appropriate standards for, no legal regulation can ever be mistake-free. That's not the standard that is appropriate to be met, but what they do show is no evidence of systematic abuse in other jurisdictions. In fact, again, read the decision. There's quite a bit. If you read it carefully, you'll see that the court is quite, to some extent, impatient with the quality of the government's arguments on this social evidence. And so the conclusion is an absolute prohibition of PAD is not demonstrably justified in a free and democratic society. So those are the elements of the decision. I want to talk a little bit about what motivated the courts to take those. I said a bit about that, but I can say a little bit more, right? So in terms of violating Section 7, the way this is sometimes presented in the media is that the court recognized, I mean, media tends to simplify things, right? Recognized the rights of autonomy of individuals, but in fact the court's decision is much richer and deeper than that, right? They said a key issue here is that physician-assisted dying actually fails to respect the value of human life. How could that be the case? Well, if you're a family doctor, you know how that's the case, right? Or probably if you're a nurse, you know how that's the case. You will have patients, say, who are in early stages of dementia, who in early stages of a terminal cancer, or who have ALS, who are looking forward to a time when they won't be able to end their own lives by suicide, and so they commit suicide prematurely. That is, before they would want to, because if they waited until they were incapacitated in a wheelchair, as Sue Rodriguez was, they would be unable to do that on their own, and the only way they could obtain early death in those circumstances would be to have somebody assist them, that is a doctor, but more likely a family member, and that they would be exposed then to being charged with murder or aiding and abetting a suicide. So the idea here is that our current laws violate not only autonomy, but the value of human life, because they force people who are facing intolerable suffering in certain circumstances to end their lives prematurely. And I'll show you a quote from the court on that topic. Right? So people are forced to commit suicide while they're able, before they're ready to die. And if my wife is a family doctor, and over the years, she comes home and we talk about these cases. And anybody who's been involved in the healthcare professions will know that this is a not uncommon feature under the pre-Carter regime of end-of-life healthcare. So the other conclusion that the court draws is that physician-assisted dying preserves the security of the person. The court thought that suffering, being forced to endure intolerable suffering, was a violation of the security of the person. And so that the idea here is that because PAD represents a way out of that suffering, the blanket prohibition on that undermines or is in conflict with preserving the security of the person and liberty and dignity. So physician-assisted dying provides, in some circumstances, a better alternative than the other alternatives that were legally available. As I've mentioned, the sociological evidence from what the court calls them permissive jurisdictions shows no evidence of systematic abuse. That is, there's no slippery slope. One of the common arguments against euthanasia and physician-assisted dying is that, well, the policy has good aims, but it'll have all these bad consequences. We start here at a good position, but we'll slide down the slope into a bad position. The court found no evidence of that, essentially agreeing with the BC Supreme Court Justice. And then the other thing, and I'll read you a passage here as well, and this is something that ethicists have argued for a long time, is that it's surprising to think that we're spending all this effort and discussing the risk of abuse from physician-assisted dying when exactly those same abuses could occur from withdrawing life support, life-sustaining treatment. And the court makes the point that there are no greater risks from physician-assisted dying in principle as compared to withdrawing life-sustaining treatment, or I'll call it WST to shorten the mouthful. Yeah. And then finally, the court concludes that it is an absolute prohibition on protecting the vulnerable is overbroad and grossly disproportionate. Part of this is the evidence from other jurisdictions shows that we can or it's possible to have a regime of physician-assisted dying without exposing the vulnerable to actual greater risks of early termination of life. Okay, so a little bit more here. This is I said I would show you some passages. This is the very first passage in the Supreme Court decision. As soon as I read this, I thought, okay, it's going to fall into place here, and it did. So I'll read it aloud. It's a decision that is beautifully written, uncharacteristically for legal decisions, by the way. People who are grievously and irremediably ill cannot seek a physician's assistance in dying and may be condemned to a life of severe and intolerable suffering. A person facing this prospect has two options. She can take her own life prematurely, often by violent or dangerous means, or she can suffer until she dies from natural causes. The choice is cruel. Okay? And if you read other aspects of the Supreme Court is concerned, I think rightly, that people in these positions will be tempted to, and family members will be tempted to assist and expose themselves to legal liability. And there is the social issue of dying on one's own. If you're put in this position, you have to commit suicide. You have to do it by yourself, because to have your loved ones around you as you die would be to expose them potentially to prosecution for aiding and abetting a suicide. So the choice is cruel, according to the Supreme Court of Canada. And there's a particularly important passage where they compare the risks of physician-assisted dying with the risks of with withdrawing life-sustaining treatment that bears special notice, because it's what ethicists, many ethicists anyway, have been saying for a long time. Here, I'll read this passage too. Supreme Court, in my view, rightly says, concerns about decisional capacity, that is, consent to PAD, and vulnerability arise in all end-of-life medical decision-making, including withdrawing life-sustaining treatment. Logically speaking, now that's probably an error. We might challenge whether it's logical, but in a certain understanding of logic, maybe inductive logic, it makes sense. Logically speaking, there is no reason to think that the injured, ill, and disabled who have the option to refuse or to request withdrawal of life-saving or life-sustaining treatment, or who seek palliative sedation, are less vulnerable or less susceptible to biased decision-making than those who might seek more active assistance in dying. Right? So, in other words, the court's saying we have the evidence that there's no clear difference in terms of risks between PAD and WST. But in addition to that, if you think about it, all these same concerns about abuse that have been leveled at physician-assisted dying apply equally to withdrawal of life-sustaining treatment. The court makes that point as eloquently as I think anyone has ever made it. So, what do we end up with here? We end up with a limited right to physician-assisted dying, and I'll go through what the court recognized people have Canadian citizens have a right to now, and I'll talk about what the limitations are, the legal limitations. That's not quite right either. The issues the court did not decide on, right? So I'll clarify that more in a moment. So, the court decided that physician-assisted dying is permitted for competent adults. So in British Columbia, this would be individuals who are aged 19 and over, who are competent, able to make their own decisions, who have a grievous and irremediable illness, and face not merely intolerable suffering, but enduring intolerable suffering, and who actively consent to physician-assisted dying. Now, what active consent means is there has to be direct face-to-face or person-to-person communication between the consenting individual and the physicians. Living wills, for example, requesting in a living will or a written advance directive that under such and such circumstances you would like to have physician-assisted dying be considered or implemented is not legally recognized by this decision. Only active consent was. Now, and the reason one of the reasons the court limited the decision in that way was that was the issue that the Civil Liberties Association, Gloria Taylor, wanted litigated. The court did not hear evidence, right, that went beyond this, because I think of myself as a member of the Civil Liberties Association board, we decided to limit the case because we thought we could get this, right? But the court makes it clear that it's not saying that there are no other legally recognized, there are no other legally recognizable rights to physician-assisted dying. It's saying essentially that we haven't yet made a judgment on that because we haven't heard the evidence on that. So it's a wise position, I think, for the court to take in the circumstances. So physician-assisted dying not recognized for competent adults who appoint proxies and have told those proxies to act as their substitute decision makers and said under the circumstances under which they would like physician-assisted dying, or who would write living wills making the same sorts of instructions. All other incompetent persons, and mature minors. So those cases have yet to go before the Supreme Court. In my view, they don't need to go before the Supreme Court. You'll see why I say that later. Okay. So the court took no position on the legality of the above. Now, before I talk a little bit about the post-Charter era, post-Carter era, I want to talk a little bit about the ethical arguments here, because the court's decision is interesting in this respect too, and its decision, again, I think reflects, as the Supreme Court of BC Justice said, reflects the preponderance of views amongst ethicists, biomedical ethicists today. So there are two traditional arguments against physician-assisted dying. Some of you will be familiar with them. One is that physician-assisted dying is intrinsically wrong, right? To administer a lethal substance is killing or murder, whereas withdrawing treatment is letting die. And this is a very controversial position defended by some people today, but certainly not by the preponderance of ethicists. We can talk about that argument if you like. I'm prepared to go on at length about it. But that's one long-standing argument for a blanket or an absolute prohibition on physician-assisted dying. The other argument is one we've looked at already, and we've seen what the Supreme Court's response to it is. That physician-assisted dying will lead to harmful consequences, such as harm to the vulnerable, loss of trust in healthcare providers, mistakes, manipulation, and coercion are the main categories that people raise when they make those sorts of arguments against physician-assisted dying. Court rejected those arguments for the class of individuals we just talked about in the previous slide. Now, it's important to see that the court had to have rejected the idea that physician-assisted dying was intrinsically wrong, right? They don't talk about that decision as ethicists would, but the very fact that were prepared to accept physician-assisted dying in some circumstances, where there is active consent in particular, means that they had to have rejected the idea that that action was intrinsically wrong. So we can say that that issue, at least in front of the Supreme Court, has been resolved by that court. 9-0, by the way, right? And then the other response the court made, as we've talked about already, is the slippery slope argument simply not borne out by the evidence that we have. Should we be surprised? My view is no. Killing, letting die argument is controversial and I think profoundly question-begging. A short response I would give to it is that it treats formalistically an issue of value. So the values that are engaged in the assisted dying debate are prevention of suffering, right? Security of the person, respect for autonomy, respect for life. Those are the things that you want to keep in mind, and it reduces it to this formalistic idea that there is a fundamental distinction between killing and letting die. But that distinction doesn't ever talk about the deeper values that are at stake. When you drill down to the deeper values, it's pretty clear that in some cases, physician-assisted dying can be clearly ethically justified according to more basic ethical principles. The other argument that the reason we shouldn't be too surprised is the slippery slope arguments prove too much, right? And the court is implicitly recognizing this in the passage that I read to you, because it applies equally to withdrawal of life-sustaining treatment. All those abuses, right? Manipulation, coercion, mistakes, and so on, apply equally to decisions to end a life by withdrawing treatment. So if we were consistent advocates of the slippery slope argument, we should similarly want to prohibit withdrawing life-sustaining treatment. And by the way, those arguments were made when I was your age. That was a while ago, when life support machines became available and became portable and became relatively inexpensive. I mean, they're still very expensive. But the issue that was raised in the late 60s and the early 70s, and we got these life support machines, who on earth is going to make the decision to turn them off? Right? And the worry was then, we can't let doctors do that, we can't let nurses do that, because that will lead to loss of trust, it will lead to abuse of vulnerable individuals and so on. Guess what? It didn't happen, right? And in fact, not only did it not happen, what emerged in the wake of that was a rather positive development. In fact, there was what we might call a virtuous slippery slope, right? That putting this responsibility on healthcare providers made them realize they had to think carefully about their choices, and what emerges as basically a new discipline in healthcare, palliative care, right? So I'm hopeful that we can have a similar sort of virtuous slippery slope emerge out of the Carter decision. If you want to see the best discussion of the killing, letting die distinction, which really depends on a very old argument from Aquinas, earlier philosophers, about the doctrine of double effect, see Alison McIntyre's brilliant discussion of this issue, fair, careful, from the Stanford Encyclopedia of Philosophy. She's updated it just recently. We could do a colloquium on that, if you like, right? So my suggestion here is, I know there is that what you really need to do is you need to look at the evidence that the Supreme Court used. It's compelling in my view. If we take an evidence-based approach to physician-assisted dying, we'll recognize there's no moral distinction between killing and letting die, or at least it's so controversial that it can't be the basis for public policy. Okay? There's a similarity of risks between physician-assisted dying and withdrawing life-sustaining treatment. The implication of that is, I think, that of 1 and 2, is that physician-assisted dying should be available in principle in any other circumstance where withdrawing life-sustaining treatment is an option. In other words, it should be on the table as an option where a decision is being made to end an individual's life. So, and that sort of extension, in my view, represents one further instance of a potentially virtuous slippery slope. Let me conclude with a few. I want to talk about one case, the Nancy Morrison case from Halifax in 1996. But before we get there, I want to set it up with my conclusion. The important issue, one that I think Jeff will probably address later this afternoon, is what should governments do? They've been given a year now to establish a regulatory regime. Can you guess what my proposal is? Okay. So given the parity between withdrawing life-sustaining treatment and physician-assisted dying in terms of the risks that are presented, since we have a regime now that we're happy with and that seems to work, and there's no evidence of systematic abuse, and there's no way further of drawing a clear distinction between physician-assisted dying and withdrawing life-sustaining treatment, one solution is to say, okay, we'll let laws around consent, the professional practice of nurses and doctors, professional standards, govern physician-assisted dying in the same way that they have effectively and in a humane way governed withdrawal of life-sustaining treatment for a very long time. Here's the argument, right? Premise 1. There are no greater risks to provide physician-assisted dying than to withdraw life-sustaining treatment. Premise 2, withdrawing life-sustaining treatment has been regulated sufficiently by laws around consent and substituted consent. There's a huge body of common law and statute law governing those decisions, and by professional standards and by the professional bodies enforcing those standards. That's our history. Combine those two premises together and you get the conclusion that there's no reason to believe that physician-assisted dying requires special or extra regulation to prevent abuse beyond what's currently in place for withdrawing life-sustaining treatment. Okay, so that's my conclusion. And there's a further conclusion. You need more premises, but I think it's intuitively obvious how it falls out. That what I'm most concerned about here is that the proposals, and we'll look at one in a moment, the proposals to regulate physician-assisted dying will change what has been a really responsible and thoughtful and humane social practice around end-of-life decision-making, something that's grown up in our society in the last 25 years, desperately needed to grow up. We'll turn that into a bureaucracy. We'll have a bureaucracy of death for people who are in need of or request physician-assisted dying. So I think that what we'll see, what I'm concerned about, and what will make this into not a virtuous slippery slope, is that what will happen is that physician-assisted dying will be stigmatized, will be rendered a sort of a bureaucracy, and that will undermine patient-centered care, evidence-centered care on behalf of patients. So, as an illustration of that, I think people need to think about some other aspects of Canadian legal history and Canadian history generally. Most of you won't know of a case that occurred in the 1990s in Halifax. It was a patient, Mr. Mills, and his doctor, Nancy Morrison. Here's the story. Mr. Mills, Paul Mills, was an extremely rugged, tough individual, suffered from an evasive and awful type of cancer, cancer of the esophagus. Over many operations, I've seen it reported it was 6, but I've also seen it reported it was 12 operations. He'd had his stomach moved up right to below his mouth, above the cancer. He was dying. He was on life support. At the time, his family made the decision to withdraw life support. His heart was exposed in the hospital. He was apparently unconscious. His tubes were oozing pus and so on. He was apparently unconscious, and it was agreed that nothing further could be done, and it was agreed to end his life by withdrawing life-sustaining treatment. That this was the most humane thing to do for this man in this particular context. Now we wouldn't talk about this case but for what happened next. Anybody know what happens in this case? Of course, right? Okay. Mills, so they withdrew life support, and the nurse McInnes, was told to administer painkillers, analgesics, if there was some distress. He started to seizure violently, convulse. She continued to load him up with opiates. Over a period of hours, and he continued to convulse. Right, Dr. Morrison was called in. McInnes later reported that she saw this is the worst death she had seen in 11 years in the ICU. And if any of you have practiced in an ICU over 11 years, you will have seen some horrible deaths. It's a given, right? So Nancy Morrison shows up, and she sees this man convulsing. She's been told about all the attempts that have been made to sedate him, unsuccessful. She administers potassium chloride, and he dies. A period of time there, Nurse McInnes didn't write what she observed in the patient charts. Later on, she did. Became common knowledge what happened. Nancy Morrison is charged with murder. Charges were then dropped. Interestingly, the judge said, she was charged with murder. The judge drops the charges and says, we can't be certain, I think almost nudge, nudge, wink, wink. We can't be certain that it was the potassium chloride that killed him or the opiates. And so there won't be enough evidence here to convict. so I'm dismissing these charges. And then he added the further interesting rider, and by the way, the prosecution can't enter a lesser charge, right? A further issue here was there was some dispute about whether the lines that connected the potassium chloride and the opiates to Mr. Mills's body were actually attached to his body. So maybe that was one of the reasons that all this was ineffective. But supposing that was the case, right? Supposing that was the case, if you read the criminal code, what should Nancy Morrison have been charged with? If you couldn't tell whether she killed him with the potassium chloride or the opiates, she's still guilty of attempted murder, right? She's still guilty of attempted murder. Court prevents that by saying, and by the way, you can't charge her with anything else. So a very interesting story. Okay, so that case, of course, Nancy Morrison would be charged with murder post-Carter, right? Or at least attempted murder. Question to leave you with: who does regulation serve and protect? My concern is that regulation is not being done to protect patients now. The proposals around regulation are not really being done to protect patients, because we have no reason to think that there's greater risk associated with physician-assisted dying versus withdrawal of life-sustaining treatment. What I think we are trying to protect are doctors and nurses. We're trying to make them feel a little bit more comfortable, maybe families as well. Is this really a patient-centered approach to care? I think it's appropriate to be skeptical about that. Here are some of the ideas around regulation that are being discussed or promoted, and several of these are reflected in the Quebec legislation that will come into place in a few days. Active consent, repeated requests for physician-assisted dying, use of official forms, right? Legal advice, waiting periods, second physician confirmation, maybe third physician confirmation, psychiatric confidence assessments, maybe even a review by an ethics committee. So those are fairly onerous requirements. They create a bureaucracy, right? And by the way, if you have ever served on a hospital ethics committee or you've been involved in these decisions in hospitals where they're made, where it's appropriate, doctors and nurses' care teams make decisions to access all these options today. They don't need to be told to, right? It's not clear they have to be told to do this. They behave in a responsible way, and they access these options as necessary. But it's not clear that they're necessary or appropriate in all cases, and so there's no need, I think, to handcuff ourselves and risk what I think is moving away from a patient-centered approach. Notice that if any one of those provisions were adopted post-Carter, Nancy Morrison would still be guilty of murder or attempted murder, right? Any one of those provisions. Okay. Okay, so there might be another way of looking at Carter here, and let me suggest this, right? Withdrawing life-sustaining treatment and physician-assisted dying are on a par with respect to risks and ethically, right? Unless somebody comes up with a new brilliant argument for the doctrine of double effect and killing and letting die distinction. But as far as we know now, and we have a tremendous amount of evidence, it's not as though there's no evidence here, right? They're on a par. This affords an opportunity, should be taken as an opportunity to improve palliative care, to integrate physician-assisted dying as an option in a palliative care regime, to improve and serve patients better, right? Regulated by the practice of medicine, regulated by the laws around consent and substituted consent that have served us well, including in end-of-life decision-making in other contexts, right? So the final thought I'll leave you is this. I think the evidence, we're going to take an evidence-based approach here. I think the evidence leads us to want to preserve physician-assisted dying as a private matter, not to say unaccountable, but a private matter, a decision that is made between physicians, a patient, and their family, in ways that are regulated, and these are robust regulations that are enforced, regulated by consent, laws around substituted consent and consent, and national and provincial professional standards. Okay, so that's basically it. I've got some resources here. I'd like to give a shout out to my colleague Alistair Brown. He and I have written on this topic. We're having a couple of things on this topic. We have a paper coming out in a couple of months in the Cambridge Quarterly of Healthcare Ethics on physician-assisted dying in Canada. And then finally, a disclaimer. Although I am a past president of the Civil Liberties Association here and past executive director, my comments today I think largely reflect the views of the Civil Liberties Association, but I'm not speaking on behalf of the Civil Liberties Association. And some of the details on the previous slides remain to be discussed before the Civil Liberties Association. Okay, so that's the presentation. Thank you.